Thanks so much, Vaughn. And Eric, you'll have to tell me if people aren't able to hear me, but I really appreciate both you all having me and again allowing me to participate via Zoom. My family remains pretty COVID cautious, and so we very much appreciate you allowing me to show up and do so from the comfort of my home. I do want to walk you through the various litigation which we've been engaged with RCAP on over the years. There have been some developments this year and a new case that we've gotten underway that I hope will shine some light on exactly what Vaughn is talking about in the checkoff. Eric, can you pull up those slides for me? Thanks so much. And if you want to go to the next one. Right, so I think it's best to think about the work that RCAP and public justice have been doing together as having three separate phases. In the first phase, we were very successful, more successful, I will be honest with you, than I thought we were going to be, in that we got courts to say the checkoff as it was being administered when we filed suit was unconstitutional. So two courts in Montana held that the checkoff prior to 2016, essentially for decades of its operation, was being unlawfully administered by USDA. We then tried to build on that win by getting the courts to more enforce oversight over how USDA was administering that program and how the money was spent. And at that point, the courts put the brakes on. And I'll explain why. But unfortunately, that's been some of the developments this year, which is that we have not been able to get the courts to intervene and say that they need to be able to supervise or to limit how the money is spent. So those constitutional challenges against the checkoff have wrapped up. And what we're doing now is pivoting and trying to figure out other ways to hold the government accountable. And we are currently suing USDA on RCAP's behalf, saying that the ways in which they brought the program into compliance with the Constitution were not properly done. Essentially, the government didn't follow its own procedures. And we're currently proceeding into what's known as discovery in that case. We're getting documents from the government. And I think it's beginning to shine a light on exactly what Vaughn's talking about how the money is being spent and the ways in which it's being detrimentally used against independent producers. And so I'm going to try to walk you through all of this in the next 10 or 15 minutes, and then we can take some questions. Some of this will be repeat for those of you who have heard me talk about this before, but particularly the new developments at the end are all from the last few weeks, in fact, and months. So Eric, can you go to the next slide, please? As a reminder, this is the public structure of the checkoff. In fact, I think this structure probably makes it seem, well, believe it or not, more clear and more easy to understand than it actually is. A lot of money flows through these channels that isn't seen here and flows to other entities that aren't seen here. But this general structure is, I think, the best way to conceptualize the checkoff. And since a case called Johans in 2005, which addressed the expenditures by the Cattlemen's Beef Board, I guess my right side of this image, I think your right side too, is been kind of off limits legally, right? The Supreme Court effectively blessed how the right side, the kind of down spike from the Cattlemen's Beef Board was being operated. And so what RCAP and public justice have been doing is focusing on the left side, particularly the ways in which money is siphoned off by the qualified state beef councils and put into largely unaccountable programs based on how the state councils pass along that money. So Eric, can you go to the next slide, please? The first win that we had, and the major win that we had, was to say that use of money by the state councils, their ability to just take 50 cents of every dollar and put it towards however they wanted to operate, was unconstitutional. As many of you know, lots of the state councils are entirely private entities. They're privately set up, they're run by subsidiaries of NCBA or others. It's effectively like taking money out of your pocket and forcing you to fund your political opponents. That's what the government was doing. It was saying you're going to take half of your checkoff dollars and put it in the pockets of the people with whom you disagree with most. And we got a court to say that was unconstitutional. That violated the First Amendment, that you have a right to not fund other your competitors' speech, and that's what you were doing. You were being forced to fund the ads that NCBA subsidiaries and others were producing, and that needed to stop. Next slide, please, Eric. What happened was that after we got that win. The government began to paper over its misconduct. And I do believe this is papering over. I don't actually think the government is abiding by the spirit of what it's supposed to be doing, but we'll get to that in a second. That they put into place these things called the Memorandums of Understanding, or MOUs, between the government and the various state councils that were privately operated. And it basically said the government was going to have more involvement in how those state councils spent money. It would get to attend meetings if it wanted to. It would look over some documents. It could access some reports. It could approve some specific of the ad regimes. Our biggest concern with this was that it still allowed the money from the state councils to go to what they called non-contractual recipients. Effectively, what happened was the MOU said, sure, there are contractors like Vaughn just listed, and the government will approve those contracts, but we're going to still let you create a slush fund for NCBA and USMEF and others by giving them money not in a contract. And we won't worry about how that money is spent. And we went ahead and challenged that as well, that the government needed to have that kind of control, in addition to saying that the actual supervision in this MOU was insufficient. Eric, next slide, please. And that's where we lost. The court said that it would not, in fact, require the government to do anything more than in these MOUs. That essentially it would not ensure that the government was actually reviewing and meaningfully weighing in on the ads. So effectively, the government turned a blind eye to how the ads were being put out. Effectively, the government could allow private speech to be paid for with your checkoff dollars. It also said that it wouldn't stop the government from allowing some of the money to get siphoned off in these non-contractual transfers. It basically said that just too minute of a point for courts to worry about is constitutional. The good news is it said that the MOUs can't disappear. The government, when we were proceeding and challenging the MOUs, made this argument, well, really, we don't need them at all. We were just doing this to appease RCAF, but we didn't have to do this at all. And we could always get rid of them if we wanted to. And the court said, no, you need the MOUs. The MOUs are the only thing that provides any form of government supervision. So we're going to require that baseline of government supervision to go forward. Unfortunately, the court would not monitor and ensure that that supervision was meaningful. And next slide, please, Eric. We took that issue all the way to the US Supreme Court. That's what happened this year. And we made two arguments. One, that the government needed to have greater involvement with the speech, or alternatively, that the court should reconsider its 2005 precedent that allowed the Cattle and Beef Board to stand. So we took a big swing and basically said the court needed to rethink this whole thing. Unfortunately, the court denied review, and it did so in a way that makes me think that it's unlikely to entertain First Amendment arguments around the checkoff anytime soon. We had, while our case was pending, there was another case raising the same legal constitutional questions before the court, where the court, in fact, did say that greater supervision was needed. It was over speech in public squares, particularly it was the municipal city hall in Boston, and what speech could occur in front of the city hall that would be government speech versus what would be public speech or private speech. And the court said if you wanted it to be government speech, if you wanted to essentially say that the government was running this and the First Amendment didn't apply because the government always has the right to speak, then you need to have more control. And we thought that kind of holding could apply to the checkoffs and could get us back into court. And unfortunately, the court denied that review. And so it suggests to us that that further First Amendment wins are going to be hard to come by here. We got the win that the state beef councils were being unconstitutionally operated. We got the win that there needed to be some government involvement. The court seemed unwilling to, as I said, police that involvement. So how do we take another run at this, knowing that the constitutional door is shut to us, at least for the moment? And Eric, next slide, please. So we tried a totally different tactic. So if the first set of cases we brought are these kind of very glamorous cases under the federal constitution and under the First Amendment, these cornerstones of our democracy. These other cases are kind of the almost inverse of that. It's the stuff about how the government runs and whether it's following its own rules and procedures. But these can be really useful cases because they hold the government's feet to the fire, and so often it's unwilling to even abide by its own basic obligations. And in doing that, we can reopen discussions and put more pressure on. We sued the government under what's known as the Administrative Procedure Act. That act basically requires the government, when it's making new policies, to allow public participation in that process. And when USDA made these MOUs, it didn't allow any public participation and was trying to do this all under the table. It was trying to do this all as quickly as possible. It didn't want to mess with any kind of criticism, right? USDA is not very comfortable with criticism, as we know. And so it just issued these MOUs without notice or comment. And what we said was that violates the Administrative Procedure Act, and that we are entitled to have those MOUs be reopened. And then RCAF can put in comments about how the state beef council should actually operate. Others can put in comments. And we can try to pressure USDA to at least bring the program more into line with what we would hope to see there. Limit the type of speech that can be produced, change who the contractors are, accomplish some of what the OFF Act requires without having to get Congress to pass a new law. And the success there was that we defeated a motion to dismiss. The government raised a variety of procedural arguments for why we were not allowed into court. And we defeated that. And in fact, the government was ordered to produce a bunch of discovery to us so we could understand how the checkoff operates. Essentially, what the court said was, I'm not sure if RCAF's members can prove a legal harm from this lack of notice and comment, but I'm going to allow them to get discovery into how the checkoff operates so that they can make the arguments and put forward the evidence to try to show that they are actually being harmed by the current administration of the checkoff, and then can reopen that current administration to allow for more notice and comments. Next slide, please, Eric. So the theory that we're pursuing is one that I think will sound very sensible to you all, which is the basic idea is that the checkoff should be administered in a way that does not increase competition against domestic producers. In other words, if the government, in issuing these MOUs, allowed competition to increase against domestic producers through the way the checkoff is administered, then there is a cognizable harm to RCAF's members that they can pursue in court. And this comes from a doctrine that is well established in DC, where we're suing USDA. And it says essentially that we don't need to prove that any individual member of RCAF suffered $1 harm because of the checkoff. We don't need to be able to extract all the other economic forces that impact beef and say, this is what the checkoff is doing. Instead, we just need to be able to say that if the checkoff is putting you all into competition with other people where you can produce, where you might otherwise be able to participate in a subset of the market, a more specialized set of the market. And that in that circumstance, the economic logic dictates that if they're competing with more people, that's going to harm your bottom line, and you can proceed in court. And this is the type of argument that we're entitled to get discovery for. And I want to show you what some of that discovery looks like. And I should be clear, we just got this a few weeks ago, and we are just reviewing it now. So this is just kind of the tip of the iceberg of what's out there. But I wanted to kind of show you a few of the documents to kind of make this kind of concrete for you. So next slide, Eric. So this is actually not a single document, but it's a series of online images that you scroll through that is published, I believe, by the Texas Beef Council, but I could be wrong about that. But it's one of the state beef councils where your money's being siphoned off. And the end message of this online set of slides that you can click through is, local beef's no different than international beef. Lots of beef travels lots of different distances, and what's really important is not the distance it travels, levels, but other aspects of the beef. So, don't worry about beef being local. It doesn't matter whether your beef's local or not. You can just assume that all beef is essentially the same from an environmental standpoint. Next slide. This one may be slightly hard to read, but this is a single page ad that's been produced by one of the state beef councils. I tried to isolate the text for you. There's a lower part that's not shown. But the message here is, 65% of all beef is lean, no matter where it comes from, no matter who produces it, it's lean, and that's what's healthy for you about beef. If you eat lean material, here it's referencing the Mediterranean lifestyle, Mediterranean diet, that's all you need to do to have a heart healthy lifestyle. So eat any that beef, the vast majority of which, will qualify. And next slide, please. And this one is obviously from the Oklahoma State Beef Council, which is, all steak is a steak. Just eat steak is the message that is conveyed here. And what we're going to do is take these examples of these. We're working with an expert, a marketing expert, who's going to produce a report where he's going to put these out to the public and see what a normal consumer, sees when they see these ads. What's the message that they take away? And we expect, and he expects from the prior research, that what we're going to see from these studies that we're going to do is that when someone sees this ad, what they do is they say, well, all beef's the same. And what do they do when they think all beef's the same? They buy the cheapest possible beef. That's not necessarily beef that I know some of you sell direct to consumer. It's not necessarily reflective of the specific conditions and rules in the United States that make raising cattle in the United States distinct from raising cattle in Canada or Australia or anywhere else. They go for the cheapest thing because people are economically sensitive. And what they keep on being told based on the ads being run by the state beef councils is, don't worry about the distinctions in beef. Don't worry about the things that we know consumers care about from like M-Cool and the rest. Just buy any form of beef and I'll be okay. And we think this study is going to be really interesting and important for RCAP to use in its advocacy, because what it's ultimately going to say is that RCAP members could be part of a separate market. They could be part of a market where of domestically produced beef, because we know consumers are willing to pay more for that. But the use of the checkoff by the state beef councils is putting you into the broader market, the all beef is the same market. That's increasing competition for you and driving down your bottom line. And that's the report that we're hoping that all these documents will eventually produce, and then we'll introduce them to court. Eric, next slide, please. So our hope is that we get these documents and we are able to put them forward in court and through the study that we're going to get. I will say that the government, because it does not like having to produce documents, is being immensely aggressive. It's asking for all sorts of contracts that our RCAP members have entered into, trying to get information into their financial data. I don't think that's because they actually intend to do anything nefarious with it. I just think it's because their hope is to tire you out, to keep you out of court by making it too difficult to stay in, because they actually have to answer for what they're doing, the courts will find against them. So the best way that the government can litigate is just to exhaust citizens from actually participating in the court process. So we're going to have to, and we are very appreciative of the members we've spoken to. We are going to have to be able to produce some documents from you all, get you all to describe how you produce beef, so then we can make this report seem, as it applies to you, that show you're just domestic and that you could be part of the separate subset, and then hopefully file later this year in court to get past this hurdle and then get to the merits, where we can get the court to say that USDA violated its own procedures, violated its obligations of how it's going to promulgate these MOUs, how it should have promulgated these MOUs, excuse me. And therefore, we need to reissue the MOUs, giving RCAP an opportunity to advocate both to USDA and on the Hill for how this program should be administered. So that's our current goal. It's a little bit less maybe appealing for the media and appealing for sounding legally interesting than the First Amendment, but this is a really useful tool to get your advocacy before the courts. And we think these reports and evidence will be valuable to RCAF no matter what the courts hold, that showing the ways in which the Checkoff homogenizes beef, basically is directly the opposite of MCOOL, is a really important advocacy point that we hope to help you emphasize. Eric, final slide. Yeah. So this is my contact information. As always, Bill knows how to get a hold of me. The others know how to get a hold of me. We greatly appreciate your willingness to work with us and deal with the government's abusive discovery practices, and that we are looking forward to working with you further on this. I'm thrilled to answer any questions now, but I also want to make sure I'm around and reachable in any of these other ways, and you can know to reach out to me. So Eric, I think you can take the slides down, and Bon or whoever else is in the room, I don't know if there's time for questions, but if there are questions for me or Bon,
speakers, go ahead. I want to just thank you first, David, for all that. And maybe I'd start with the first question. If your MOU deal is successful, what do you perceive will happen? Will those states be shut down immediately until they can work something out?
Yeah, that's a whole complicated area of law as to what happens when there's a procedural violation in terms of whether they have to revoke the rule or they just can rework it while the rule stays on the books. My strongest guess is that this is really a lobbying and pressure point tool for you all. That if the MOUs get reopened, it's a mechanism for RCAF to put pressure on to change how they're written, because they'll have to be reissued. And hopefully then you can put limits. Like you could say, oh, the state councils can't engage in these non-contractual transfers. They can't just pay money into the federation if that money is going to be used in a way that just homogenizes beef. There needs to be some acknowledgement of the differences in beef. You could get those kinds of changes, but I don't think you're going to get a shutdown, because that's a very big step. And again, this is a complicated and its own unique area of law.
Dave, this is Frank Andrus out here in California. Is it possible that if this thing would get to the point of maybe getting some relief on it, that one of the things that we could get through that might make it a little easier is to call for another referendum without having to get the high numbers? They made that so onerous and so difficult that nobody has ever had the courage to go out and take that on.
Yeah, so I've got two different answers to you. One is that, what the specific case is focused on the MOUs. But the nice thing about litigation is that, particularly if you win, you get into a room with the people on the other side and you get into a discussion about what kind of changes are possible, and then you can potentially settle. If that's what you all want to do, that's certainly something we could discuss. We're a little bit away from there, and I think that what the hope is that this will highlight this. I think what our best hope for you is that the kind of expert report we're talking about producing is a tool for you to then go to people like Booker and Tillis and the other senators who are on the Off Act and say, we now have evidence that this is harming us. We need to change this program immediately. And it's a way to pressure not just USDA, but legislators to move some of these other rule changes that you all are looking for.
What I'd like to see him do is call for a referendum right now, as soon as possible, and then make it automatically every 10 years that we have a referendum on that. And also,
it is kind of shocking you don't have one
the,
more often than once. Yeah, sorry, I cut you off there.
And then also make it mandatory that the number of voters must be at least 45%. These commodity checkoff programs out there in California, I think nationally, are the same. The participation is so small, and to put taxes on the people with such a small percentage of the producers voting, it's really not fair. Out there, they
made it effectively like impossible to undo one of these programs. I think that's right. That what you all did, and I think Baum was really right about this, was yeoman's work. That was a hard fight, and getting what you got was more than was expected because the whole thing's set up for you all not to succeed.
Oh, that's right. My own personal experience in that is, I contacted, of the 90, or the people I contacted, 99.9% of them voted just overwhelmingly against it, and so, or in favor of the referendum. So that was really interesting, and I had more darn fun going out getting those signatures, because for the first time, and I've gone out getting signatures on memberships and donations and everything else, and oh heck, you're lucky if you get 50% of the people will give you something. On this thing here, my gosh, just like I say, 99.9% of the people were just in favor of it, and then I made new friends in adjoining communities, and they patted me on the back and everything else. It got to be really a lot of fun.
Anybody else for David? David, thank you very much for joining us.
Great, thank you so much.
Yes, thank you, David. I want to thank all of you for listening to this presentation. I guess it's working better now. And I'd like to leave you with one thought, and that is, it's just $1 on those cattle. Why should I be concerned about that when I've lost $250 to $500 per head since Cool was killed? Well, it was that dollar that killed Cool. There was 5 of those contractors on there that signed on to that petition to get the House of Representatives to drop Cool in June of 2016 on there, and they got the job done by threatening that there was tariffs going to be imposed on a lot of people on there, currently on there. So it's time that we do something about who contracts for these checkoffs. And the beef checkoff is not alone. The dairy is having big problems, and a lot of the other checkoffs on there. I called it a gravy train, and it is a gravy train for beef organizations, but there's gravy trains for all the others on there. With that, I thank you. I guess you ready to take over? Anybody have any other questions, comments, or anything? I would suggest that you think about our ways of doing this, the litigation, the legislation, possibly the off act, and if we should try and go for another referendum, how we do that. I'm not sure. The referendum was told that it was either for or against on the thing, and I don't know if USDA determines what the referendum's going to say. And technically, the referendum was nothing to have. It was just to have a vote. We couldn't even get the point. They fought us on there because they were scared if we had a vote. And I think 38,000 signatures by one organization and a staff of 4 dedicated women and all you people out there running around, that was remarkable, and I thank you.